Welcome back to everyone. I see that our next tandem session is already in position to start. So I'm very pleased to introduce the last and third junior-senior tandem session today, which is composed of Yannick Vogel. So Yannick is a doctoral researcher in the Law, Science and Technology Joint Doctorate Rights of Internet of Everything. And his doctoral research focuses on the topic of neo-commodification of persons, the exploitation of personal data and impact on the sharing economy, influenceable autonomy and predictable freedom in the Internet of Everything. And we paired Yannick with Nadezhda Purtova, who is Associate Professor at Tilburg Institute for Law, Technology and Society. And she does research on data protection, informational privacy law, recently in the context of health, regulation of health technologies, property rights in personal data, data commons, and economic analysis of data protection law. So today, Yannick will present his paper, which is about the anonymization of group data under the GDPR regime, a blessing in disguise. And with this being said, I would leave the floor to Yannick and then, of course, to Nadia to react to his research.
All right, can you hear me? Can you see the PowerPoint like this?
I can hear you very softly. I'm not sure if the others can.
Is this better if I speak up?
I'm not sure, like Nadia, maybe if you could let me know whether you can hear him better than how I do.
That would be a shame. Giorgio, if you're still in the building, can you lend me your laptop? Let me see if I can get my microphone levels up.
Now it's much better. This is perfect. Thank you, Yannick. Yes, right. Thank you.
And if I do it like this, does it work again? Is it all good?
Yes, right, this is fine. Thanks.
Then I guess I'll dive right in. So thank you for the invitation. Thank you, Professor Purtova, for doing this tandem session with me. My name is Yannick, and the paper has been properly introduced. So the main question of this project that I wanted to work on, the starting point of it really was, in what manner can big data analysis of anonymized group data negatively impact the informational self-determination of individuals? And as you all know, in academia, sometimes somewhere down the road, you realize that perhaps you didn't pick the right concepts to square off against each other, and I think we'll have a case of that here. But the outcomes are still pretty interesting, I think. So the roadmap of this presentation is going to be as follows. I'll talk about the type of data that I've looked at, the data protection framework, and the European future strategy of data that applies to this. The way big data analysis works on anonymous group data and the value production that can be deduced from this. We'll have a short recap to see how these concepts all align, and look at a case study of the Havasupai case, which was a group of Native Americans. And then we'll get to the point of informational self-determination, and we'll possibly see how, excuse me, and then we'll possibly see how these concepts all converge. So to start off with the who, what, where of anonymous group data, I tried to look at data that is exempt from the GDPR scope for two reasons, really. It does not relate to an identifiable or identified natural person. So it breaks the link between the person and the data, and it breaks the link between the relatability of such data sets to individual persons. So we're talking about data of more than one person that has been anonymized and then de-identified. Now, the two main points of critique here that we've already heard are that anonymization in practice might be really tricky, if not impossible, and that a very broad reading of the notion and the concept of personal data stretches so far that perhaps anything at this point could be considered to be relating to a natural person. So first off, let's start with the European strategy for data, because I think this is really important in the concept of the content of the picture that I'm trying to paint here. My reading of the European strategy for data is that there's an active call to group and to pool data, and that is still strictly based on the idea that there is either personal data and non-personal data and nothing in between there. The idea is that citizens should be empowered to make better decisions based on the insights gleaned from non-personal data, and that the data should be available to all. Of course, I understand this in the context of the global innovation challenge that we face in the race between other global powers who have perhaps a less stringent data protection or privacy regime that allows them to really make steps that the European Union cannot at this point. And so the last point that I want to highlight before we get into the case in a big data context, because what I see is that it opens up possibilities to price discrimination, social segregation, which is not necessarily based on the targeting of an individual. And also, as we've just heard in the discussion between Pier Giorgio and Michael Vale, is that companies try to avoid targeting individuals or dealing with personal data, because it is possible to create value without targeting individuals and working on a more collective level. And I found this best illustrated by the following excerpt. Legally speaking, many companies prefer not to personally identify you. The less they know who you are, the more they are legally allowed to learn about how you are. So to recap all of the previous, there is group data that is exempt from the protection of the GDPR as far as it doesn't trigger Article 4.1. The European data strategy is an active strategy to combine and pool such data in order to further its economic potential. And big data analysis of such anonymized group data does not require individual targeting, individual identification to serve economic purposes. And so what I've tried to do is examine a case of the Hoovers tribe, which to my knowledge is a group of Native Americans in the USA. And this experiment was conducted under US law. So there's no GDPR applicable. There is no data protection framework there. It's the idea of American privacy law. And what happened in this case was there was a group of Native Americans called the Hoovers tribe, which basically gave up their anonymized blood samples, I believe, to a researcher who anonymized them, pooled them all together, and then passed them on to a different researcher who performed an analysis on all of these, on this anonymous data set. Now the results were pretty shocking for the people of the tribe when they found out, because on a collective level, it turned out that the high level of diabetes that was present in their tribe was most likely to be attributed to extensive inbreeding, and that one of their spiritual leaders of the 1800s was most likely heavily schizophrenic, and that the tribe as a whole was most likely from Siberia and not from the Grand Canyon as they believed. And so what this illustrates is that there was a clear impairment of the development and the maintenance of individual identity, which in part functioned on a group level. And by attacking this group level, you see that it has severe consequences for the individuals here. Now, there are two important features to distinguish between the big data analysis of anonymous group data and this case of the Hoovers tribe. That is that first, the members of the group could identify each other, which made me think of what Mr. Haase said a little while ago about the people who live in Kreuzerstraat. The people who live in the Kreuzerstraat have the ability to see who else lives in the Kreuzerstraat, and they know who lives there. And this is different in a big data context, as we'll see. And a second point in the Hoovers tribe case was that the results of the analysis became accessible to the group. Somehow the results of the analysis turned back to the group. And this is really in contrast with the current analysis of anonymous group data in a big data context, because groups cannot identify each other as easy as as the Hoovers tribe can. And that is primarily because if you look at the way that big data analysis works, it often puts the conclusion before the hypothesis. And in that sense, it sort of reverses that narrative. And the second point is that the results of the analysis are often kept at lock at those who possess the data advantage. The EDPS called this tight corporate secrecy a little while ago. And so now what I'm wondering is if we take all of this together with the strategy shift in which insights gleaned from non-personal data becomes available to all, could we envision cases where big data analysis of anonymous group data on a collective level affects the right or the development and the maintenance of individual identity? So the concern here is that we might run into a situation where it becomes increasingly possible to access insights of more granular groups of people, yet completely circumventing the scope of personal data and circumventing the idea of individual targeting. And my fear is that in the future, if we keep on going down this path and indeed make anonymous group data available to all, we are going to increasingly find groups of people who will find outcomes of analysis about the groups that they implicitly belong to, whether or not they are targeted as individuals. And in a certain sense, this relates quite closely to, for instance, statistical analysis. If we think of people who live in Amsterdam North or people who live in Amsterdam South, we know that one is richer than the other, but still this does not work on a granular enough level to really impair the right of the individual to maintain or create a identity. And second of all, big tech is probably engaging in these practices, but we don't have the right legal tools to find out yet. So the concern, in essence, is the concern for safeguarding the individual integrity of personal identity in cases where no personal data is processed and no individuals are targeted. And I would like to also suggest here that I do not believe that this is a case where anonymous data is made back into personal data, which would have the GDPR apply again. And so this is where I perhaps erred a little bit in my paper, because I couldn't conceive a situation where individuals had absolutely no control over this data and over these practices. Because the idea of informational self-determination is in essence the capacity of the individual to determine in principle the disclosure and use of his or her personal information, which in turn is a tool to safeguard that right to the development and the maintenance of a personal identity. And where I messed up a little bit is that I thought that informational self-determination was one of the objectives of the GDPR, and that we would be in control of our data in the GDPR more than it is present in the articles. But as Professor Purtova writes in 2014, by dividing privacy and data protection law, you essentially keep informational self-determination at in the privacy field, while making the data protection field more a risk-based tool with different default entitlements. So I fear that this was an incorrect juxtaposition, but this still leaves us with the question, how do we control protection and maintenance over individual data in cases where we have very little to say from a procedural standpoint that is safeguarded by the GDPR? And so to wrap this up a little bit and perhaps start the discussion, if data protection and privacy both aim to protect identity and the idea of autonomy and self-development, but do this in very different ways, in what way should we evaluate the risk that I've just tried to lay out here? And would you agree with me that there are cases in which we can see that anonymization of data is very counterproductive to the idea of protecting one's identity and the essence of the right to data protection and to a certain extent of privacy. So I hope I've made myself clear enough in a certain sense, and we'll probably have a lot to discuss. So if you want to take over, Professor, then I'll be glad.
Just let me share my screen here. Oops. Can you see my screen?
Yes.
Yeah. Okay. So first of all, Yannick, it was a great pleasure for me to read your paper. Also, because as I understand, you are the alumni of the Law and Technology program in Tilburg. So it's nice to see what happens to people when they leave. What I'm gonna say now is a response to your paper, and I hope I will be able to correct a little bit, to adjust my response to what you said just now. And it's also going to be sort of my reflection on basically the thoughts that your paper triggered, given my own research interests. And so the chief issue in your paper that you raise is indeed basically what is within and outside of the scope and of the reach of the ambition of the data protection law, both in terms of the wrongs to avert or values to protect, and the tools that the GDPR has at its disposal, including the concept of personal data, which sets out the material scope of the GDPR. So roughly, basically, the paper's central thesis can be broken down in three parts. First, the GDPR does not have a collective dimension, which I would say partially agree with. Well, mostly you're right. The collective dimension is really very limited. Then the processing of group data, while outside of the GDPR scope, since it's not personal, still has a potential to cause undesirable consequences. So violate informational self-determination of the group members, but then you corrected yourself. I would read it as basically impact identity building of the individuals in the group. And the second undesirable consequence, which you sort of mentioned but didn't really articulate in detail very much, is the sort of the knowledge is power consequence. So the group data also gives power to those who hold the data over individuals. And then finally, the GDPR does not have the tools to address these wrongs. So I will not talk about the first point, but about the 2 and 3. In terms of processing of group data impacting informational self-determination, I think, well, sort of we are clear here. Indeed, it's not so much that the GDPR doesn't have a purpose to protect the informational self-determination. I mean, the GDPR is the sort of it's a servant of all masters. Whatever fundamental rights you have, the GDPR is supposed to serve them if the protection of those rights requires the protection of personal data. So perhaps in part, the GDPR will also serve informational self-determination, but it's very limited. But the thought that I had while reading your paper was, well, is information self-determination, does it have a collective dimension? Sort of, for instance, consider history as the ultimate group data. Basically, everything, does information self-determination or my freedom to build my identity, which is also influenced by my group identity as a member of, for instance, the Russian people, does it give me a claim to suppress historical events or information about the historical events? And then haven't we always had limited control over our sort of group identities, or the part of our identity that sort of comes from being a member of a group? So this is really a question rather than a criticism, especially that now you've left out that point on informational self-determination. So is information self-determination really the problem with the group data? So you also concluded that not. And so my attention was really drawn to what you mentioned, but didn't really develop, as basically the fact that group data gives power over groups and individuals to treat them in a certain way. So say, if I visit a web shop, an algorithm based on my previous browsing behavior puts me in various groups and classifies me in certain ways as a woman between with neurotic tendencies, prone to spontaneous purchases, or whatever other group constructs they have. I am basically affected by the group data. Or the recent example in the British schools, the use of basically the average grades per school were calculated to estimate the final school grades of the school children. So there is a problem that when we are talking here really about these invisible algorithmically generated groups, the members of those groups indeed cannot resist being placed in the groups, for instance, or resist generation of information about the groups because, well, for the reason that those groups are invisible and their generation is opaque. For instance, discrimination, while it's prohibited only on certain grounds, can happen in the so-called calculated publics on other grounds, let's say, which can escape the radar, the legal radar. And what I thought would be useful perhaps for you to consider is the STS scholarship on basically the search terms I would recommend would be network publics, algorithmically generated calculated publics, and known and unknown publics. This is really the literature that addresses this invisible algorithmic generation of groups. So, and then the third point that you raised, or the conclusion that you make, is that the GDPR has no tools basically to help against these potential wrongs. And so I will basically give some sort of marginal corrections on this slide. You will see basically the marginal points, and then I will address a more fundamental point. So some limited solutions would still be present to address the wrongs of group data in the GDPR. So in particular, in the case of this Native American tribe, but also in other cases. I mean, at some point, this group data was personal data. It was relating to identified individuals when the blood samples were collected. And for instance, in the European data protection law, the ground for processing genetic data would be informed consent, explicit informed consent, which has to be based on understanding of consequences. So these revelations that basically came out of the analysis of that data, the members of the tribe should have been informed about such possibility, that they might find out something that they wouldn't like to know. Then there are other checks and balances. As Michael said, basically it's hard to find a data set that at some point hasn't been personal data when we are talking about anonymous or anonymized data. Then there are also other checks and balances in processing data before anonymization. So for instance, the purpose needs to be legitimate, which also, well, and then the processing must be strictly necessary to achieve that purpose. So no less intrusive measures should be possible. So basically, there are multiple opportunities within the GDPR at the stage before anonymization. And we should remember anonymization is also processing of personal data that can basically address the issues that you raise in this particular case. But this is not a foolproof solution, of course. First of all, I mean, not every instance of processing happens on the basis of consent. And then the fact that the data processing is invisible also basically deprives us, pragmatically speaking, of many tools of control of what is going on with our data. But I think indeed what you are mostly interested in, and the fundamental issue really here, is the relationship between the GDPR and those algorithmically generated publics, or the data on those algorithmically generated publics. And so I want to interrogate this a little bit. So does the GDPR really have nothing to offer in terms of protection when we are talking about group data and algorithmic publics in particular? So that comes down to the question, does group data fall, perhaps, or under no conditions fall within the scope of the GDPR. And here the defining provision, of course, is the definition of personal data, which is information relating to identified or identifiable natural person. So my answer would be that harnessing group data power may still fall under the GDPR. Why is that? Well, we agree that group data is information. It can relate to natural persons, to many, but this is not an obstacle for a piece of information to be personal data, as we find out basically from the Court of Justice decision in Novak. Personal data can relate to multiple persons. And then basically the threshold, the real threshold here is whether or not this data relates to an identified or identifiable natural person, where identified relates to the fact of identification and identifiable to the possibility of identification. So there is a lot of literature, and two of the keynotes today were about the meaning of identifiability or the legally relevant chance of identification. I will not talk about that, but I think, and let's say here, the third keynote today was really a surprise for me, and a happy surprise. Basically, now I would like to talk really about what is identification and when is data subject identified. So is the group data not relating to a data subject who is identified, or data subjects who are identified? So, and here, basically, the meaning of identification in the GDPR is not limited to establishing civil identity. So what your name is or what your passport number is and such. So Article 29 Working Party defines what it means to identify as basically to identify means, according to the Article 29 Working Party, to distinguish somebody from a group. One important remark here is that some question the validity of this approach, since the Article 29 Working Party does not really produce binding guidelines on how the GDPR has to be interpreted. But let's still proceed with this. Basically, there are several accounts in the literature of what it would mean to identify in a sense of distinguish from a group. And so here I consider the work of Ronald Lanus from 2007, but also Gary Marks wrote basically wrote about that in 1999. Basically, indeed, you can distinguish a person from a group in a number of ways. So it can either be done via so-called lookup identifiability, when through a registry, directory, or table that provides the connection between an individual, let's say on the street, and his civil identity, you can establish the civil identity of a person, for instance, using the identifiers such as name, passport number, phone number, etc. Then there is a so-called recognition identifiability, when you do not care about who the person is in real life, but you care about basically recognizing that person every time you encounter that person. As an example, basically this is done by means of using an identifier or token or feature set, such as a facial template, for instance, known or recognizable as valid. So if there is a facial recognition camera hanging somewhere on the street and they keep the facial templates, and then they learn that the same person passes by every week at the same time, this would be an example of recognition identification. Then there is classification identification. According to Lanus, you can also identify individuals as members of a particular pre-existing group and category. So this is, I think, interesting here. So the purpose of a classification identification is really not to recognize or even more so establish who that person is in real life, but to attribute to an individual certain characteristics and treat him accordingly. And then there is the last variety of identification, which is session identifiability. And the aim is to track a user during one interaction session. So At least 3 of these types of identifiability or identification fall under the GDPR meaning of identification straight away: lookup, recognition identifiability, and session identifiability. If we understand identification as the ability to distinguish, with classification it's slightly more difficult, in a sense that it does fall within this meaning of identification when the profile or group data is intended to be or is applied to an identified or identifiable person in a sense of, for instance, lookup, a recognition, or session identifiability. So basically you take group data and you stick it to a person with an lookup, recognition, or session identifier, and to what extent that person would be identified depends on the context. But it might not also be the case when we are talking about general classifications, whether or not we are talking about when we are classifying people into man, woman, zip code, basically depending on the zip code, etc. So here, the notion of k-anonymity is relevant. If the members of the group are more than one, it's not going to be an identified individual we're talking about here. But there are also, let's say, what I propose is to basically refine this notion of classification, identification a little bit more, in the sense that there is also unique classification, especially when we are talking about algorithmically generated classifications and algorithmically generated groups. So in this case, it can happen that basically an overlap of classifications is applied to the effect that only one person fits all these characteristics. Only one person is the member of that group. Usually it requires recognition identification or a session identification, but it doesn't necessarily have to. So an individual is classified on contact as belonging to multiple groups where the overlap of classifications is unique. And so the groups or classifications can be obvious or not obvious in the case of the algorithmic publics. And in this case, personalization would also be distinguishing from a group and fall within the scope of the GDPR. So this is also consistent with the GDPR definition of the data subject, who is identified or identifiable natural person. And the identifiable natural person is the one who can be identified directly or indirectly, in particular by reference to an identifier or an overlap of sort of non-unique identifiers. So this part of the definition, in my opinion, basically explains in what way an individual can be identified. And one of the ways is by an overlap of non-unique identifiers, for instance, sort of group classifications. So let's consider an example. In an offline setting, I would be able to subject somebody to personalized treatment based on my basically life experience or prejudice, whatever I have. I see somebody passing by and I think you're an unpleasant person, probably have just drunk beer, yelling a lot, basically displaying the behavior I do not like. I assume things about you, even if I don't know you, I've never seen you, I do not recognize you, I will never recognize you probably 2 weeks from now. And basically I subject you to a certain treatment, as in I don't want to talk to you. And then in the online setting, a similar situation can be reproduced when based on real-time on-contact, for instance, sensor readings or facial detection, posture, gait detection, combined with other available data, the system uniquely classifies you and treats you accordingly. For instance, makes decisions, displays personalized news, advertisements, etc. So this is about the whether or not a group data is always non-personal, let's put it this way, or under which conditions it can be relating to an identified natural person. So in terms of concluding remarks, what lessons sort of do I want to draw from here? First, it is possible to construe group data as personal data when it is used to classify or treat in a certain way an individual. And that individual does not necessarily have to be identified in a sense of recognition, looking up, or even session identifiability. But Having said that, I do not think that the problem of group data is completely resolved here, because this personalization, the group data is not always used in this way. Let's put it this way. It's not always the case. And so effect and or impact the data processing, whether or not it's group data, on people is more important than identification. And basically what I have just done is a very interesting piece of legal gymnastics, I think, and I think it's a valid, basically, legal argument to interpret the notion of identification. And I think for the purposes of providing, as we have, basically there is this emerging principle of complete and effective protection in data protection law. For the purposes of pursuing that principle, we indeed should interpret the notion of personal data broadly. And here the question comes, do we overstretch the concept of personal data, and here in particular the concept of identification? You have seen that there are various types of identification in this social science account of identification, which actually raise different problems. So perhaps the recognition identification, lookup identification raises the problems of privacy in a conventional sense of the word, whatever that is, or confidentiality. Whereas, for instance, session identification is a totally different ballgame. And so the GDPR then ends up to be an instrument that tries to address with the same tools a very broad range of problems. And this is a problem sort of in itself, as I see it. So if automatic classification, making and using group data as a means of decision-making needs to be addressed, well, perhaps it can be addressed separately and not necessarily within the GDPR, finding for basically ways to do it via backdoor. So that was all I had to say on the paper. And I think we can open the discussion in the panel. Thank you. So we have 4 questions. An anonymous attendee is asking, doesn't this example of Havasapi tribe just portray that the knowledge pool of the tribe was weak, and thus in turn understanding of themselves was based on scarce knowledge and led them to misunderstanding or misidentifying themselves? Or should we say, should we just live by ignorance is bliss principle? I think we've tackled that a little bit when we talked about the limited control over one's identity when it depends partially on the group identity. Yannick, do you have anything to add here?
No, I think this is quite an interesting point that the anonymous attendee makes. I wouldn't, in a split second, be able to really say that I would disagree with the idea that we cannot live by ignorance is bliss principle, especially in the context of the way in which we find out more and more about the groups that we live in and about ourselves through the analysis of the data that we leave around everywhere. Let me see it again. No, I wouldn't have a clear-cut answer for that right off the bat.
Okay, neither would I. I suggest we move on. The next question is quite interesting. What are the goals of the GDPR, in your opinion, if not informational self-determination?
Well, in my opinion, the GDPR is a mechanism in which we balance societal interest of processing of data versus the interest of the individual, is right to the protection of fundamental rights, of which informational self-determination also is one.
Well, I fully agree with the answer. I would rather also like to add that sort of the GDPR is a jack of all trades and master of none, a little bit, in a sense that I'm not sure the drafters of the GDPR really have a very clear idea of what really the goal of it is, except for providing protection for all we can think of that relates to the internet. And I think this is one of the core problems of the GDPR. Another question. An anonymous attendee is asking, if there are results about a group I belong to, and nobody, even a shop, knows or can assume with sufficient probability that I belong to it, I don't care. As soon as somebody has the knowledge that I am a member of the group, it is linked and in the result personal data under the GDPR. I would say I would agree with this statement, but I think we need to enter a little nuance here. Nobody in the advertisement industry cares if the group, let's say, if the group data is applicable to you as an identified by a name and surname and the postal address. What they are concerned about is basically the individuals on the other side of the screen. And they don't, let's say, they don't care about your actual, they do not care to find out if it's you. They just care to find out what characteristics an individual on the other side of the screen at this given moment of time has. And so basically, I think what the nuance is about is the strength of this link that you mentioned between the individual and the data. And I think that a big misconception is that this link has to be to an individual who is identified or identifiable in a sense of recognition or look-up identifiability, whereas it's a much broader notion. And it's a little bit of a circular discussion here, because indeed it's common, or it's a widely accepted proposition in the data protection scholarship that, for instance, a profile or group data, when applied to an individual who is identified or identifiable, is personal data. But then the question is, who is an identified or identifiable individual? And here is where the interesting sort of debate begins. Next question, asked by Aiste. Shouldn't we be looking at the impact of group data processing and its implications? Should data protection legislation address some of such implications? I absolutely am with you there. I'm not sure if it should be data protection law that addresses this, but I think we are just missing an alternative legal. We expect everything from the data protection law. Maybe we should reconfigure the protection against digital harms in a way that doesn't put all the weight on data protection law. I agree absolutely there should be some protections against the negative consequences of processing. Yannick, would you like to?
Yeah, I was thinking about how you would envision such a more general protection on harms of group data. Could you think of a collective dimension, or would you think in the direction of general data management laws, rules and principles of what you can and cannot do?
That's a great question. And I think that the same point was also raised during the keynote session. Sort of, if we do not tie protection only to the notion of personal data, what then? Let's say, and it's hard to think because we are so used to using this notion. It's a legacy notion. We've worked with it for so long. It's difficult for us to imagine how the system of legal protection would work based on other trigger concepts. But for instance, in terms of impact on people based on processing of group data or whatever data, what is important here? Let's say, basically what we have to look for is we have to look at these problems differently. We have to try to problematize them differently. So what is really the problem? Is it the data that is the problem and hence needs to be regulated? Or is it perhaps technology or business models that have to be regulated? So perhaps the decision-making as practice just has to be regulated. or automated decision-making has to be regulated as practice? I mean, there are many alternatives, and unfortunately, I cannot provide a conclusive answer at that at this moment. So, and the last question, the one before the last. Indeed, the key problem, I think, resides in classification identifiability, which, as you said, can be hardly framed within the GDPR definition. The problem is an adequate assessment of the risks for individuals. Collecting an attribute belonging to you might have a very bad impact on you without you being identified because of statistical data previously collected and decisions made on them. And the individual expectations might be very far from the consequences that belonging to that group might have. I agree. I think it's more of a statement rather than a question. But Yannick, would you like to comment on this?
Well, I think the next question is, do you have solutions? So perhaps we could start on that. Let me just quickly read this again. On the part of the individual expectations one might have, on the consequences that belonging to one group might have, I would like to add to that that it is going to be increasingly difficult to have any control over that, because as I tried to explain a little bit, finding patterns in data sets doesn't focuses on certain questions being asked. The answers almost present themselves without the question being asked. The conclusion sort of comes before the hypothesis. And in that sense, I very much wonder if people realize the degree to which they're being grouped and have no idea about how this is working.
I think we've run out of time.
Yes, and I think we also finished all the questions. Oh, there is a last one, I believe, if you want to quickly answer to this.
Well, automated decision making is already regulated in the GDPR. Do you personally think they're effective, sufficient? It's quite a big question in the sense that there are a lot of tools to regulate automated decision making, such as the right to explanations, the entire field, basically. The automated decision making in the sense of Article 22 doesn't cover decision making based, basically not involving processing of personal data. And as we discovered, it is sort of such processing can still exist. So it doesn't address all the dangers of automated decision making. This is a brief answer.
I would like to add to that Article 22 requires a legal or equivalent effect, which sort of narrows the scope of the way that.
Yeah, that's also a good one. Let's say what sufficiently significant, or let's say similarly significant effect. I think we are still yet to discover what that means. Let's say on an individual level, the effect can be marginal. But then, for instance, whether or not you see targeted content on the internet, yet on the aggregate level, on the level of society, the impact can be basically quite significant. Does that count as similarly significant effect? Yeah, basically we're far from the final solutions. I think we should stop at the moment.
Okay, yes. On this note, I would like to thank you both for this really interesting session. And I think these 3 sessions perfectly set the scene also for today's final panel discussion.